Good morning, everybody. A very warm welcome to our second construction and engineering webinar of 2022, which is our construction law summer update. My name is Stefan Harris-Wright. I'm a partner and head of construction engineering at Burkitt's Solicitors. Could I have the next slide, please?
So a brief word for you here about our firm, Burkitt's. Hopefully most of you will have heard of us before, but in case you haven't, there is some information at a glance for you on this slide. I won't go through all of this in detail, but just in summary, we are a top 60 full service law firm with 5 offices across the east of England and also in London. Now, I know there's a really, having looked down the delegate list, there's very much an international feel to the audience today, which is fantastic. We don't actually have any international offices ourselves, but we do regularly work for clients around the world in English law jurisdictions. Also worth mentioning is that we're part of a network called IAG Global, which is the International Advisory Group, which is a global network of law firms who cross-refer work to each other in different jurisdictions. So if you or a client you're working for need advice on non-English law jurisdiction matter, then we can certainly put you in touch with a reputable local firm who can assist you. Could I have the next slide, please? So I will take the opportunity now to introduce our speakers for this morning's session. First of all, we've got Derryn Rolfe. Derryn's a legal director in our construction engineering team. We're also joined by our colleague Maria Peyman, who's a partner in our litigation team. She specialises in contentious intellectual property matters. And last but by no means least, we have Patrick Cooney, who's a legal director also in our construction and engineering team. So welcome to all of our panel. Could I have the next slide, please? So briefly to summarise what it is we're going to cover this morning, Derryn's going to give us an update on the Building Safety Bill, now the Building Safety Act. Maria's going to talk about copyright matters in construction context. Patrick's going to give us an update on some recent interesting construction and engineering cases, and then we'll have a chance at the end for a Q&A. So a few housekeeping bits and pieces before we get into the main part of the session. There is an opportunity to put your questions to the panel through the question function in the GoToWebinar portal. The questions come through to me and not to the panelists or the other delegates on the session, so you will remain anonymous. So please don't be shy with your questions. Some of you have sent in questions in advance, which is great. Thanks for those. It's a very strong turnout for this morning's session, so we'll do our best to get through as many questions as we can, and if we can't do all of them in the time available, we'll do our best to follow up with individuals afterwards, and we'll look to draw proceedings to a close by midday. Finally, the session is being recorded and we'll circulate that either ourselves or via the CICES to delegates afterwards, along with a copy of the slides. So that's definitely enough from me, and without further ado, I will hand you over to Derryn to tell us about the current position on the Building Safety Act. Derryn.
Thank you, Steph. Good morning, everybody. The Building Safety Bill spent quite a lot of time in Parliament being chewed over and agonised over, largely because of the costs involved in the whole of the recladding issues arising after the Grenfell disaster. But it did finally get royal assent on the 28th of April of this year. And as of last week, as of the 28th of June, some of the first provisions are now actually in force. So the reason we've got the Building Safety Act at all is basically to avoid another Grenfell tragedy. There are 2 prongs to the approach behind the Act. The first is the remediation of existing potentially defective housing stock in particular, and the second is to improve the building standards across the industry, both in housing and other buildings. The Act is extremely large. It's got 171 provisions. Some of those are not going to be relevant to the world of civil engineering surveyors. Some of them are going to be relevant to everybody because they affect the entire industry. Because there is such a huge number of provisions, and some of them are quite specific to different areas of the world of development, I'm not going to be able to go into them all in depth today, otherwise we'd be here, frankly, for several days. So it's going to be more of a whistle-stop tour. We are planning on doing a series of bite-sized recordings on individual topics under the Act shortly. So if you need more in depth on anything, that will be available soon. So why we all need to know about the Building Safety Act? Firstly, because it contains some very onerous requirements on the industry in terms of how buildings are going to be built, how they're going to be managed, and how the safety of individuals using them is going to be hopefully assured in the future. Secondly, because it brings some quite significant changes in the structure and the procedures for building approvals and complaints about building defects and safeties. Thirdly, because it extends the liabilities for old and new defects and construction products well beyond the normal limitation periods in English law. And finally, because all of this is going to be expensive. So everybody needs to know about it to avoid it becoming unnecessarily expensive. So what the Act covers is the whole life cycle of a building, from idea through to actually occupation and management. Everybody and anybody involved in development, construction and management of buildings is going to be affected by the provisions of the Act. What it does, how it goes about doing this, is it amends provisions of two existing statutes. The Defective Premises Act, which obviously only applies, well, not obviously, but does only apply to residential buildings, and the fundamental requirement of the Act is that buildings should be fit for human habitation. And it also amends the provisions of the Building Act, which is where all the building regulations and various other things all come from, and that applies to all buildings. So it's not, there is a perception that it's just about high-risk residential blocks of flats, but it's not. It actually affects all sorts of buildings in all sorts of ways. There are obviously specific rules for what it calls higher risk buildings, and higher risk in this context is defined as buildings where there is some residential element of the building, so mixed use and resi only, that are either 18 metres or seven stories from the floor upwards. There's several lines about how it defines what 18 metres from ground upwards is, and I would have thought, frankly, it was quite obvious, but it is a very thoroughly drafted Act. So as an industry, what we need to prepare for, the first thing we need to prepare for, because it's the first thing that's already now in force, is for the claims. The claims for defects, the claims for injury and loss arising from buildings not having been built properly in the past or going forward. So both the Defective Premises Act and the Building Act, which cover resi and non-resi, as I've said, have got new limitation periods for claims. Now, this is a seismic change in English law. Everybody knows it's just one of those sine qua non things that that you've got 6 years of its contract, 12 years of its deed. That's the limit of your liability in terms of time. Now, however, for claims that are relevant to the provisions of the Act, you've got claims arising after the 28th of June. The liability is now 15 years, and claims arising before the 28th of June, it's now 30 years. There are obviously a lot of things that are currently being considered in the industry about how we deal with this, both from how we draft contracts all the way through to what the insurance industry is going to do about this. But it certainly seems as though, with other things that are in the Act, that the 15-year liability is something that is very much kind of landed on the industry now, and we're going to be stuck with it in the foreseeable future. So that means that because there would have been a lot of claims, particularly for cladding in the past and for other defective buildings problems, that there would have been time barred because they were more than 12 years old. Now there's 30 years, there's going to be an awful lot of claims happening. For the people who've suffered loss, it's fantastic. It's an opportunity for them to get back their losses and be compensated for their injuries and damages, which they wouldn't have been able to otherwise. The industry, however, it is going to be a very expensive and time-consuming business. The other thing that's already in is a whole new cause of action specifically for defective construction products. Now, anybody who's watched the Grenfell inquiry will understand why this has come about. So that the concept is that construction products that have caused damage or injury, that have been missold or have been used not in accordance with the manufacturer's instructions requirements, so installation issues, or that are inherently defective, can now be sued upon as a specific cause of action. So you wouldn't have to try and prove that it was not in accordance with the some other kind of commercial act or general use or something like that. You can specifically say it's a construction product, it was missold, therefore I can sue on it. And for those as well, the limitation is also 15 years from now on, and 30 years for claim backwards for claims arising before the 28th of June. Now, the day on which the claim arises is the breach of contract, as it was already. But again, that's 30 years worth of missold products that there could be an awful lot of claims on. So the other things it needs to prepare for are probably of less importance to members of CICES in some respects. So, for example, all new homes will have to have a warranty that, again, is lasting for 15 years. At the moment, most homes have some kind of insurance policy like NHBC that tends to last for 10 years, of which the first two are only really the relevant ones, because after that, quite a lot of things are excluded. We haven't yet seen the shape of the new warranties because there was only the Act only got royal assent on the 20th of June and it wasn't published till the middle of May. So nothing's really happened in terms of knowing what's properly come in yet. So it'll be interesting to see what these warranties are expected to actually cover. But it is going to be obviously a 50% increase in the time span for warranties than previously. The Act brings in a new building safety regulator. This person or office is going to be part of the Health and Safety Executive, and they are going to have a lot of things to do. I do hope that they don't really intend to sleep anytime soon, because they are going to be in charge of overseeing not only bringing in a variety of these schemes like the warranties for new homes, but also a new system for registering, teaching, approving the building inspectors. There is going to be, from when it comes in, we haven't got a date on this yet, but it will be within at the latest 18 months from the 20th of April, a new system where all building inspectors have to be on a registered, mandatory registration, and inspectors who carry out the job of inspecting and indeed approving without being registered can be subject to not only a fine but also a custodial sentence. All of the failure to do the requirements in terms of managing and developing buildings now under this Act are actually criminal offences. So it's not something that the government is messing around with. They clearly are intending to make sure that it is complied with. There is going to be a new ombudsman for all new homes, including social housing, where previously social housing tenants who have a problem with their issues can't. There was no ombudsman. You had to go to your MP, and of course, they've all got far too many things to do to be bothered with people. So there is actually now a decent route of sort of complaining and getting redress via a new ombudsman. And there is going to be a whole new management regime for the higher risk buildings. So for each building, there will have to be an accountable person who is responsible for safety, a duty holder. There will have to be a pack of information about the building itself that's called the golden thread of information that covers everything from design all the way through to day-to-day management. So that's going to be quite onerous for people like managing agents who look after blocks of flats or whatever. The plan is, though, that the onerousness, the work is not on the leaseholders themselves, not on the individual residents. It's going to be on the management company, and they will have a duty to appoint these various people. And if they don't, again, there's fines, there's custodial sentences, and there's all sorts of actual things in the Act. I say there's 171 provisions. There's all sorts of things they've actually got to do to try and ensure that the residents are going to be safe. There will be new gateway systems for buildings approval that might be of more impact to the members of CICES in terms of how you're allowed, how you go about applying for building regs before you even start. So there will be new hoops to be jumped through in that process. There will also be the ability for the Secretary of State, as recommended by the new regulator, to prohibit specified persons or types of persons from actually being involved in development, to stop them from applying for building rent approvals at the outset, which is a very sort of massive new departure, the fact that you can actually say you're not fit to be doing this. In addition, there will be a building safety levy. There has to be money in it somewhere. The levy will be spent apparently on ensuring public safety, but there's no details yet as to how much that's going to be or exactly how it's going to be spent. So that's a very quick roundup of what's in the new Act. As I say, we will be doing in-depth webinars on individual parts, and obviously if you have any questions, we'd be happy to help. But next, I'd like to hand over to my colleague Maria, who's going to tell you about copywriting construction, a very important topic. Thank you, Maria.
Thank you. Thank you, Derryn, and good morning, everybody. As Derryn said, I'm going to look at copyright in the construction context this morning. It really is just a gallop through of some high-level points, starting with, if I could have the next slide, please. What is copyright? And then we'll look briefly at who owns the copyright. Why are copyright works important in the construction sector, to give you that contextual setting? Then how we go about securing the right to use copyright works when we don't own them. And lastly, as a footnote, I'm just going to touch on a couple of cases which highlight the need to be aware of where copyright ownership rests, particularly if you come in partway through a development. Could I have the next slide, please? So what is copyright? Well, copyright is an intellectual property right which protects the form in which ideas are expressed, as opposed to just protecting just the idea itself. And it arises provided that the work is original and not a copy of an existing work. And it gives the copyright owner the exclusive right to copy, communicate, distribute, issue, publish, and adapt the work as it sees fit. Then anyone else can only do all of those things with particular works if they have the permission or consent of the copyright owner. The sorts of documents that are touched by this within the construction sector are drawings, design details, specifications of materials, plans, and reports prepared by or on behalf of the contractor or consultant in relation to the construction project. It also extends to include anything that's created during the course of a project, obviously, and it covers not only hard copy works, but also electronic format works, and ultimately the building itself. So in summary, it's the pictures and the words around a project, and then the building. Next slide, please. So who owns the copyright? Well, on a statutory basis, in accordance with the Copyright Designs and Patents Act 1988, the person who creates the work, which we generally refer to as an author, is the owner, with a couple of exceptions. So the statutory exception, which the most obvious example is where the works are created by employees in the course of their employment, and in which case the ownership vests with the employer. Or if there are contractual terms of the appointment which say otherwise. So for example, an assignment of the ownership within the contractual terms. If I could have the next slide, please. But why is it important to the construction sector? Well, the preparation and use of the copyright materials, which we identified in the initial slide, are required to be used by various parties at various stages of a project life cycle. So, for example, the developer, the contractor, a professional consultant, and then onwards into the life of the building owner, a tenant, a managing agent, or at any point a party providing finance in relation to the project. But you need to be assured that all of these parties can use the copyright materials without fear that they are going to be accused of copyright infringement. And so that's why it's important. So if I could have the next slide, please. How do we go about securing the right to use those works? Well, I'm going to look at two elements of this. One, you can seek to get a license, and we'll cover it in more detail shortly, but we're going to look at what does the license give you. A standard wording that you might come across in standard contracts, and then negotiating the terms of the license. So you might need or want additional terms, or the people that you're contracting with might want additional terms. And then I'm going to look at assignment, and what does the assignment give you? Why would you want it? And can you even get it? So next slide, please. Moving to licenses. So a license of a copyright allows you to do certain things with the work, but does not impart to you ownership of the copyright. Owners of copyright usually keen to retain their ownership, unsurprisingly, but a client who's paying for the works usually wants to be able to use the copyright works freely and without issue going forward. So the licenses are sort of compromise between the two, because it gives a right to use, and that can either be very widely or narrowly, depending on the wording, which I'll touch on in a moment. But it also allows the copyright owner to retain the ownership and thereby some degree of control about how it's used going forward. So within the construction sector, there are some standard contracts which have a sort of base level clause regarding licenses for copyright works, and the commonly found wording is that the license is an irrevocable, royalty-free and non-exclusive right to use and copy the copyright materials for any purpose connected with the project. So what does this mean in real terms? Well, irrevocable means it can't be terminated, and there are obvious reasons why you would not want a party to be able to suddenly terminate their license when the copyright works may be material to the whole project, usually are, but also you may have already put them to use, and actually trying to extract that would be almost impossible. Royalty-free, again, it's hard to police how people are using these going forward, using the works, provided it's within the terms of the license. And you've paid upfront. Often the licensor has paid significant sums for the work, and they don't want to be worrying about having to pay again in the future. Non-exclusive, which I'll come back to in a moment, but the non-exclusive right means that the copyright owner may then want to and be able to license it to other people, and that may or may not work for the licensee involved in the particular relationship. And then we have the copyright materials for any purpose connected with the project. Broadly defined, and arguably from a licensee's point of view, nice and broadly defined, can use it as they see fit, when they see fit, with who they see fit. Not ideal, perhaps from the licensor's point of view, however, because do you want copyright materials to be all of the materials you've prepared that they can use without coming back to you? Perhaps not. There may be some reason why you wouldn't want to license them, their use, or not license their use without further remuneration. And for any purpose connected with the project, if there was to be an add-on to the project or a further development in the future, would the licensor actually be happy for those documents to be used without further remuneration? And that may be or maybe not. So from a licensor's perspective, broadly drafting is not necessarily in their interests. In fact, there is some argument to say it's not in the licensee's interest either. The trouble with broad drafting, as you may find, is that it becomes very open to interpretation, which in itself can then lead to disputes between parties involved. So increasingly what you find is that people are more specific. Copyright materials specifies exactly which documents you're referring to, and any purpose connected with the project will also be defined to particular purposes connected with the project, and the project being defined more specifically, so that everyone is clear exactly as to the parameters of the license, and also where the licensor may be then entitled to say, actually, now you need to come back to us, and we either need further remuneration or more discussion. And that leads into my next point. So the standard clause that's found may be sufficient and parties may be happy with it, but in fact, there's nothing to go on for there is nothing to stop the parties continuing their negotiations and expanding on that very basic wording. For example, to include the ability to sub-license. So if you know you're going to have to allow people within your supply chain to make use of the copyright materials that you've paid for, then you want that ability to sub-license without any issues for either you or your sub-licensee. Permission to transfer the license can be material, and we'll actually see how it becomes material in the cases at the end of this topic. But the permission to transfer the license is also quite key. You might know that you're not going to develop out or complete the project for various reasons, or in fact you may not know, but you might want to have that benefit there that you can then choose to transfer the license in appropriate circumstances. You might also want to restrict the copyright owner's ability to reuse the copyright works, which is something I've just touched on in the non-exclusive right. You know, do you want the copyright owner to be able to give that work to competitors for a competing project or within the marketplace? And it's something I'll touch on again when we look at assignments. And also ensuring the license continues beyond the life of the contract. This is obviously linked to the irrevocable point. You don't want to find that your license for the copyright expires when the documents have been incorporated into a now fully formed building. Just briefly to touch on implied licenses, increasingly not needed. Why would you? They're inherently risky. If people are discussing implied licenses, it's usually because there's an undercurrent of dispute or disagreement bubbling beneath the surface, and it entirely relies on people arguing what the actions of the parties were, their understanding, and so that risk is inherent and therefore unusual to want to rely on implied licenses. Increasingly not needed. If standard wording features in contracts that you're putting to use, then there's absolutely no reason why you would not want to have at least the bare license that may feature. Moving now, please, to the next slide. And assignment of copyright. So what does assignment mean compared to a license? Well, the assignment means that the ownership of the copyright is transferred and you become the entire owner of the entire copyright materials that are in relation to which ownership is assigned, and you can do whatever you want with them because you are the owner. Generally in the UK, it's considered that a suitably worded express license, perhaps negotiated as we've touched on in the previous slide, is usually sufficient for most projects and most clients within the UK. And on that basis, why would you even have assignment? Well, just because there are some parties who like to have assignment. They want to control everything, they want to own everything, and they want to make sure that they are fettering anybody else's use of those copyright materials. If you know that the client you're dealing with, or perhaps the parties you deal with in turn like this, are this way inclined, you may be accepting of that, or you may even incorporate a premium effectively to balance that effective transfer of all rights in relation to those works. The alternative reason is because there is a commercial sensitivity or particularly valuable element to maintain market advantage within the works. So for example, if they relate to a particularly iconic building, or perhaps it's a modular construction system that's depicted in those copyright materials, that people want to preserve that exclusivity and that protection of those from being utilized or copied in some way by another party. But you have to also then consider whether an assignment is even possible, because actually it may be the case that the party that you're contracting with, who is going to hopefully assign or license you the copyright materials, may not be in a position to assign because they have in turn used something from someone else and are subject to their own terms of a copyright license. So in circumstances where maybe an assignment is not appropriate because it cannot be done, or because the copyright owner does not want to part with the ownership, then you could consider an exclusive express license. So exclusivity in a copyright license means that the licensee is able to use the copyright materials exclusively, including to the exclusion of the copyright owner, oddly, but the copyright owner retains ownership. If I could have the next slide, please. So as I said at the outset, I'm going to finish by just touching on two cases. There are relatively limited cases actually on this general subject matter, but these two highlight the importance of contractual provisions to anticipate change, and from the perspective of the licensee to anticipate change, but from the perspective of somebody stepping into the project, perhaps acquiring the development or taking on the role of developing further down the line when documents, for example, already exist on a planning portal. It's a note to remind ourselves to make sure that we've got the ability to use those documents, and if you haven't, to obtain permission to do so. So in Signature Realty, Signature had submitted drawings in order to get planning permission, and planning permission was granted, but on condition that the development was per the approved drawings. So that in itself, not unusual. Signature then couldn't fund the purchase of the land, also potentially not unusual, and the landowner sold it to the defendants, who completed the development and sold it on. The defendants, in completing the development and selling it on, used the submitted architect's drawings for the purposes of promotion, marketing, construction of the development, and the court was asked, amongst other things, to consider whether or not the planning permission itself belonged to Signature, whether the drawings were sufficiently original to attract copyright in the first place, and whether the defendants were liable for copyright infringement. So the judge held that planning permission didn't belong to the claimants, as anyone could apply for planning permission. There was sufficient intellectual skill in the drawings depicting the proposed use of the available space in order for copyright to subsist. So copyright did subsist in the drawings. And lastly, that copyright had been infringed by the defendant's use of copies of the drawings for marketing or architect tendering estimating purposes, and also in order to make AutoCAD versions of the same. But in relation to the constructing of the building only infringed the drawings in some respects. Derryn and the Shand Partnership, it's actually a Scottish case, but it bears relevance because the legislation is largely the same for copyright purposes. So Derryn was a Scottish architect pursuing an infringement claim against the Shand Partnership. So Derryn had prepared the plans for a development company, which had approached the owner of the site with a view to purchasing the site. The agreement between the architect and the development company was a standard REBA, as at that time, terms and conditions, and the architect was paid in full, so Derryn had been paid in full. Planning permission was obtained, but the agreement to purchase fell through, and the architect then became aware of the planning application submitted and being built out by the Shand Partnership, but not the developer that Derryn had done the work for. So the defendant argued that the architect had impliedly licensed their drawings to the new developers who owned the site on the basis that they had been paid in full for the drawings, and therefore any owner of the land now or in the future would be entitled to use those, obviously having been submitted for the planning permission. The architect said that couldn't be correct because their terms and conditions clearly prohibited assignment of the agreement without written consent. None had been obtained, and there was an express license to the original development company to use the materials in the way set out. And on that basis, you couldn't have an express license and an implied license. And the court actually agreed with the architect, and the Shand Partnership were considered to be infringing. If I could have the next slide, please. So those two cases are just a reminder about the importance of checking your position in relation to documents. Just because something has been put onto a planning portal or has been made available to you by somebody else doesn't necessarily mean to say you have the right to use it. So lastly is my checklist on provisions for copyright. Just some points to remember. Do you have a license to use the copyright works? If so, are the standard terms sufficient? Do you need to negotiate additional provisions to suit your needs? And if you're acquiring a site where existing copyright works are material, are you able to use them? Thank you, that's all from me. I'm now going to hand over to Patrick, who's providing you with a case update on some construction and engineering cases.
Thank you, Maria. There are 3 cases I'm going to talk about today. If I could have the next slide, please. So the first case is called Advance and Eniska. Advance with the main contractor, Eniska with a subcontractor, and it's about Payless notices, as a lot of cases are in the construction world, and whether a Payless notice can apply to 2 different applications for payment. So Eniska was the subcontractor. So they issued their application 24 in October of last year. And then the following month, on the 19th of November, they issued the following application, number 25. Now, the main contractor, Advance, didn't respond to the October application, number 24, at all. So they didn't issue a payment certificate, and they didn't use the second bite of the cherry either. They didn't issue a Payless notice either. What the main contractor did do was issue a Payless notice, which was in time, by the way, against application 25. And the Payless notice referred to payment application 25 only. So no response at all to application 24. So if we move on to the next slide, we'll see what the subcontractor's reaction to that was. Well, there was no Payless notice, no payment certificate against application 24. So Eniska, the subcontractor, claimed it was entitled to the full sum that applied for in that application. And that's a well-established principle. If there's no response to an application at all, and no certificate, no Payless notice, that money is due and payable. It's a case of pay now and argue later. That's very much established, and I've given on the slide there the case of S&T and Grove, which is probably the most recent authority on that principle. They won their adjudication. The adjudicator agreed no valid payment notice had been issued against application 24. So what did the main contractor do? Well, Advance issued Part 8 proceedings in the courts. So Part 8 proceedings, that's a claim for the court to make a determination on a specific issue rather than a trial in the general sense. And they asked the judge to determine whether that Payless notice issued in response to application 25 was valid against number 24. Well, what was their basis for saying that? Well, they said that as that November Payless notice made it clear that no payment was due on the project at all, that principle should apply to all existing applications as a matter of common sense. And significantly, it was issued in time. So it was issued in time against both applications effectively. So if I could have the next slide, please, we'll see what the court said. The court didn't like that argument at all. They agreed with the adjudicator, and the judge said that a payment notice or a Payless notice must refer to an individual payment cycle. So the court talked about payment cycles because in each construction contract there'll be a monthly usually payment cycle, could be by stages, but there's a process every month or whatever it may be to get to payment, the application, the certificate, the Payless notice, the final date for payment. So that's why the court talked about payment cycles. And what the court said was all these payment notices, the purposes of them all is to identify what the notified sum is for the purposes of the Construction Act. and that's the sum that becomes payable. There's nothing in the Construction Act to suggest a payless notice can apply to two different payment cycles. You need one per cycle, one per application. So they upheld the adjudicator's decision. So takeaways from that case, well, quite obviously, you need a payless notice for each payment cycle, for each application, and you must specify which application your payless notice is responding to. That makes it very clear that any breaches of the payment regime and the requirement to issue notices will be upheld by the courts. So one per application is the key message. No such thing as a general payless notice, which can be used against multiple applications. Okay, on to the next slide, please. I'll talk about an insurance case. This case is about joint insurance and subrogation rights. So a couple of words on what each of those principles is, just to set the scene. So joint insurance is where you have a single policy that insures more than one party. So if an employer takes out an all risks policy and the contractor or a consultant is a joint name, it means that each party has their own separate insurance policy. They're each covered by the indemnity. Very different just from being noted on a policy. That sometimes gets confused, but being noted really gives you no rights at all other than the right to be made aware that a claim's been made under the policy. You don't have any insurance or indemnity under the policy if you're merely noted, if your interest is just noted. And subrogation rights are an insurer's rights to recover what is paid out. So in a normal scenario, let's say the employer suffers a loss due to defects on a project. They're covered by their policy, whichever one it may be. The employer pays out. Obviously, the insurer pays out. The insurer is then out of pocket, and subrogation is their right to step into the shoes of the employer and bring a claim in the employer's name or whoever the insured party's name is, and bring a claim against the relevant supply chain member to recover their outlay. So that's what a right of subrogation is. It's stepping into the shoes of your insured party to recover what you've paid out as an insurer. So a quick look at the facts on this one. It was for works to upgrade the Twickenham Rugby Stadium in time for the 2015 World Cup. Don't know if anyone remembers who won that one, but it was New Zealand again. The works included installing high voltage power cables, always ripe for a claim when we see reference to high voltage cables. Now the RFU were the employer, and they engaged Conway as the contractor to install the ductwork. Conway were engaged under a JCT with insurance option C. So the RFU had to take out an employer's all risks policy in joint names covering damage to the works. So Conway were named as a co-insured party under that policy, as option C requires. Now, it's important to note that the JCT states that damage caused by defective design or workmanship is excluded, big difference, from that all risks policy. So there's no need to insure that. And that's quite standard for an all risks policy. That's where PI comes in. RFU discharged its obligation to take out the all risk policy, but they did it by taking out a wider project policy, one that covered the whole supply chain, subcontractors as well, but that's how they did it. You sometimes see that on big projects. There were defects in the ductwork, surprise, surprise, otherwise I'd have nothing to talk to you about. There was £4.5 million worth of loss, and the project policy covered the RFU, so the insurer paid out. They then brought a subrogated claim against Conway to recover what they'd paid out. Now, Conway said, you can't do that, you can't sue us because to the insurer, because you are our insurer. You know, under that all risks policy, we're jointly insured with the RFU. You can't bring a claim against your own insured party, which is absolutely right, because it's a sort of fundamental principle of insurance law that an insurer can't bring a claim against its own insured party. Otherwise, what would be the point of insurance? That the insurer would pay out and then sue you to get it all back again. So the issue is whether Conway were insured to the same extent as the RFU. Next slide, please. Thank you. So the court rejected Conway's insurance defence, co-insurance defence. It was key that the JCT, the underlying JCT, didn't require the RFU to insure Conway, for defective design and workmanship under that all risks policy. That's the excluded element of that insurance. So Conway were an insured party under the all risks, but they were covered for the usual things like fire and flood, and their own defects were excluded. Now, there was nothing to stop the RFU taking out wider cover for itself, and it did that. So in the event, Conway were not co-insured for the loss, or not to the same extent. Effectively, the RFU had a greater coverage under the policy than the contractor did. So for the loss in question, damage resulting from design from defects in workmanship, Conway weren't co-insured under the all risks policy. So the RFU's insurer was able to bring its claim. If you have a look at the next slide, I can just touch on a couple of lessons learned. Just be aware that the fact that you're jointly insured on a policy doesn't mean you're jointly insured to the same extent as your employer in this case. And it also shows us that a standard employer's all risks policy won't cover a contractor in that sort of joint names element for defects in design or workmanship. And that shows the benefit of having your own insurance. That's where your PI comes in. Make sure you've got the right level of PI that will cover you for design defects. Workmanship defects are thought generally to be uninsurable, less relevant to engineers, but they can be insured under an all risks policy, but it would require an extension to the policy, which would be quite expensive. But just bear in mind that it's the underlying contract which will determine how far these joint policies go, and it tells us how you benefit from always making sure you're covered by your own insurance rather than relying on others. Okay, next slide, please. Just a few words on a brief on this, because it's an established principle already, but it's been reaffirmed by the Court of Appeal. So the Court of Appeal held recently that a collateral warranty can be a construction contract for the purposes of the Construction Act. Why does that matter? Well, it means that disputes under a warranty can be referred to adjudication, which not everybody would have been expecting. Quick recap on why. Well, the Act applies to agreements for the carrying out of construction operations, so building contracts and consultant appointments all qualify. A collateral warranty given after the event, after PC, you would think not. But in Abbey, the judge said the contractor had warranted to perform and continue to perform its obligations under the contract diligently. And that future-facing promise, that promise to carry on into the future, made the warranty an agreement for the purposes of carrying out construction operations, so it qualified. And the judge also said the fact that the warranty was given and executed after PC made no difference. It had that promise as to the standard of the work going forward. Next slide, please. We can just have a quick look at a previous case which determined the same principle. It's not a new principle. The TCC, the Construction Court, decided the same principle in Parkwood, again on a similar principle. But in Parkwood, it was key to the judge's decision that the warranty included the phrase warrants, acknowledges and undertakes in that future-facing promise. Those words weren't present in the Abbey case, only warrants was, but the judge says, well, the absence of acknowledges and undertakes makes no material difference at all. If it's got that future-facing promise, then that will qualify. Just coming back to why that matters, well, I think beneficiaries under warranties may not have been expecting adjudication to be an optional dispute resolution process, and equally engineers, employers, those giving the warranties, so not employers, contractors, engineers giving the warranties may not expect that that could be used against them, that fast track dispute resolution process. So just bear in mind that a lot of warranties now will be considered to be construction contracts on a standard wording. So adjudication will be available as well as court proceedings for resolving disputes under them. Okay, that's a quick canter through 3 key cases from the last 12 months. That's now going to welcome everyone back in for the Q&A session.
Brilliant. Thanks, Patrick, Maria, and Derryn for those very interesting sessions. Right, so we've got some time left before midday for some questions, and some questions have been coming in, so I'll launch into these without further delay. So Derryn, I'm going to come to you first. There's a question here about limitation periods, which is, when does the cause of action arise under the new limitation periods?
The arising of cause of action hasn't changed. It was always from breach of contract, and so it's from breach of contract now. So it's just that if you can sue now if the breach of contract was up to 30 years ago.
Okay, excellent, thank you. Maria, I'll come to you next. There's quite a few questions about your copyright session, and the first one of those was, are terms like perpetual and worldwide appropriate, presumably in the context of a copyright license?
So taking perpetual first, this is actually linked to the irrevocable point, and it is a case where having a never-ending license is appropriate, because if a licensor could terminate halfway through for no particular reason, just a desire not to have a license anymore, developers, contractors would find themselves in some degree of difficulty, especially given that ultimately there will be a building which incorporates probably parts or all of some copyright material. So yes, it can be. I suppose you'd need to consider the copyright materials and just make sure it is relevant, but one can see the relevance in these particular circumstances. As to worldwide, licenses generally, you like to have something more specific, and this comes down to that very broad wording. What does worldwide mean? Or we try and avoid things that can change as well. For example, using definition of EU, because it's subject to fluctuation, as we've recently experienced. And so often there'll be a territory definition, and you'll have the territories identified. However, on a very top level, it is possible to do that, because copyright, unlike registered intellectual property rights, which are by territory, copyright can be enforced in multiple countries by virtue of being signatories to the Berne Convention. So, for example, the UK is, and a lot of other countries around the world are, and we offer reciprocal provisions to the owners of copyright. So hopefully that addresses that point for them.
Very good, thank you very much. Patrick, I'll come to you now. A question here about Payless notices. So you talked about the timing of Payless notices. The question is, what are the contractual requirements under a JCT contract for the content of the notice, and how much detail should it contain? Well, this is something that's always, well, comes up a lot, doesn't it, in the context of disputes that we deal with in the team.
Exactly, yes. I mean, there are 2 key requirements to a Payless notice. Make sure it's issued on time, which we covered, X number of days before the final date for payment, and your contract will confirm that. And then make sure it's adequate in terms of its content. So a Payless notice has to set out 2 things: the lesser sum due, and then the basis on which that sum was calculated. So practical points, well, following on from the cases we discussed, make sure you issue 1 Payless notice per application or per payment cycle. Call it a Payless notice. I mean, you don't have to do that, but why would you waste time on challenges around labels and things like that? Specify which application you're responding to, specify the lesser sum that you're paying, and then set out your maths, your calculation as to how you've arrived at that lesser sum. In terms of the level of detail, I mean, the courts won't like artificial challenges about whether enough detail has been gone into and whether the basis has been properly set out. I mean, I think the practical advice is set out your calculation in a reasonable level of detail so that your maths makes sense in terms of how you've arrived at the lower figure. That's really the nub of it. I would say don't append calculations, or sorry, don't refer to calculations from previous weeks which aren't appended. That hasn't been fatal to Payless notices in the recent cases, but it causes a lot of dispute. So just don't allow yourselves to waste time on that. Append any relevant calculations and set out your maths in a reasonable level of detail, and make sure your sums add up.
Fantastic, thanks Patrick. Derryn, come back to you on building safety. Question here about the regulator. So what will the building safety regulator actually do?
The building safety regulator is going to be like the spider in the middle of the web. They are going to be controlling the setting up of all the new schemes. They're going to be controlling who, when things are enforced, who's actually doing things. So, for example, at the moment, higher risk buildings, as I said, are defined as over 18 metres or 7 stories and having one or more residential units in them. But the building regulator can make proposals to the Secretary of State that other types of building or specific buildings are included in the category of high risk, where all the new the extra administrative systems, I'll put my teeth in, are going to apply. So there's an awful lot of things that they are going to have the power to do, and fundamentally I think what they're going to not do is sleep an awful lot, because there's an awful lot of new schemes that they are going to be involved, well, in charge of rolling out and then ensuring that they are complied with. So they're very much going to be the linchpin in the whole safety of new buildings systems.
Excellent, thank you, Derryn. Right, we've got time for one more question each for Patrick and Maria. We'll give punchy questions and punchy answers. Here we go. So Maria, question from the floor here. If you receive a drawing from a party, is it your responsibility to check that you can use it, or does it sit with the person who issued it? Question from a main contractor.
So it doesn't really matter where you sit. It's your responsibility, to be honest, because copyright is what's known as a strict liability tort. So it doesn't matter if you did it inadvertently or it comes to you without your knowledge, you can still be responsible or liable for infringement, and people can bring action against you for infringing their copyright. Also, if you do ask the person expressly and say, have you got, do we have the requisite permissions, or have you obtained them? Then if they were to give you false information, you might have a recourse to them, which, absent asking anything at all, you're going to find yourself in some difficulties unless you're going to argue was implied. But so the short answer is yes, you should.
Excellent, thank you very much. Right, Patrick, last one for you. Not something which we talked about this morning, but something I know you've looked at in a lot of detail in the past and spoken about in the past, which is fitness for purpose. Is there any case law where a claim was brought on the basis of fitness for purpose?
Yes, there's a long line of case law. The key case on that is a case called Hogarth, and what that showed us is that if you agree as a contractor or as a consultant that your liability is reasonable skill and care, but you also happen to agree a fitness for purpose obligation elsewhere in the contract, and in that case it was tucked away, the obligation, in deep in the technical spec, then the court will hold you to both standards. So if your T's and C's say reasonable skill and care, which is obviously the standard threshold, and then tucked away in the spec you've actually agreed and warranted fitness for purpose, in this case that the wind turbines would work for 30 years, then the court won't reduce your liability back down to skill and care. It'll hold you liable for both standards. So you will effectively be held to that higher standard. So the key message there is check the technical spec documents very carefully for anything which would affect your liability profile in that way.
Fantastic, thank you very much. All right, so here we are, 1 minute past 12, so very close to keeping to time. I will draw things to a close now. So that's all we have time for. I hope you found this morning's session informative. When the session ends, you'll be invited to submit your feedback, including suggestions for things you might want to hear about from us on in future sessions. So if you do have a minute or two to fill that out, it's very much appreciated by us in terms of guiding us and what you want to hear about when we next meet. So all that remains for me to say is thank you once again for joining us. I hope you have a good day, and we hope to see you next time.